Greetings! Welcome to episode 8 of our Courts and Trials series. Today we are going to look at juries. Juries are one of the key foundational pieces of our courts and trials system. The Constitution guarantees everybody the right to trial by jury in criminal cases. However, as we've talked about, only a small percentage of cases ever reach a jury. And the professional or judicial view of juries is not the most positive. Listen to these quotes. These are from actual court opinions that judges wrote. This first one comes from a federal intermediate court of appeals. It says, in this case, De Leon did not refuse to plead to the drug counts in order to preserve a legal challenge to the statute, but because the government would not dismiss the firearms count in exchange for his guilty plea. De Leon retained the option to plead guilty to the former and to contest the latter charges. Instead, he chose to roll the dice in the hope that he would be acquitted on all counts. Listen to this next quote. It comes from Judge Richard Posner, who is often considered to be one of the leading candidates for a Supreme Court nomination at some point in the future. He's also an intermediate court of appeals judge and a highly regarded legal scholar. He writes this in a case: a misrepresentation that makes the defendant think that the sentence which he is inviting by pleading guilty is longer than it really is will rarely induce a plea. For normally, the heavier the sentence invited by the plea, the less likely the defendant will be to plead rather than roll the dice for trial. So here are two different appellate court judges who are saying that going to trial is really nothing more than a roll of the dice. First, we look at jury composition. How many jurors do we actually need? How many jurors are ideal? What are we required to have? Just about every state and the federal government that uses juries will go with a 12-person jury. So if you go back through any type of popular culture references, you always see a 12-person jury. In fact, 12 people. But do we have to have 12? Can we have fewer than 12? The Supreme Court has said yes, we do not need to have a 12-person jury. So what's the minimum number that we can have? According to the Supreme Court, the minimum number we can have is 6, because the court says that psychological research shows that deliberative process begins to be impaired once we get below 6 people. In particular, we tend to lose diversity of viewpoints, diversity of opinions, and as a result, we need to have at least 6 people on our juries. States such as Florida, Louisiana, and Oregon tend to use only 6 people on their juries. However, as I said, most states do tend to use 12. Another important question with our jury composition is, do they have to be unanimous? Again, when we look at popular culture references, we're often told that juries in criminal cases must reach a unanimous verdict. However, that is not necessarily the case. Just about every state does require a unanimous verdict, but some states, and the Supreme Court has agreed, do not require unanimous verdicts. We don't know exactly what the division can be. Some can be, in theory, 7 and 5. You could have 8 and 4. The Supreme Court has at least said that 10 to 2 is sufficient for an outcome. From there, we now have the question of what happens if we combine these things? What if we have fewer than 12 people? Do we still need to have a unanimous verdict? The answer to that question is yes. Anytime you have less than 12 jurors, you need to ensure that you have a unanimous verdict. So that deals with our composition. The next question is, how do we actually select this jury? Who do we want to serve on the jury? The truth of the matter is, neither side in the case wants an unbiased jury. Both sides want to get jurors who are going to be most favorable to their case. Go back to episode 7, when we talked about the adversary theory of trial from Gary Goodpaster. You have those competing sides. They want to win. They are champions of their viewpoint. And so one of the ways to achieve that is to make sure you have decision makers who are favorable or who are predisposed to your particular viewpoint. The idea is that if both sides are attempting to get jurors who are favorable to their side, they will be seeking to get rid of those who are not favorable to their side. And from that process, we will get 12 people who can be fair and impartial to both sides. So how do we decide who is going to be sympathetic to our case and who is not? The answer to that is by asking questions. There would be the beginning of every jury trial is the jury selection process, whereby either the judge or the attorneys, or sometimes both, will be able to ask questions of the potential jurors. They're basically, when they're asking these questions, looking for two important things. The first is, can the person be fair and impartial to both sides? To put that a different way, we're trying to find out, is this potential juror biased towards one side or the other? If the answer is yes, the juror is going to be removed. The second thing that we're looking for is, does this potential juror have the ability to follow the law as the judge instructs it? If the juror cannot follow the instructions, then that juror will also be removed. These removals are what we call cause strikes. Both sides have an unlimited number of cause strikes. Anyone who cannot be fair and impartial, anyone who cannot follow the instructions as the judge gives it to them, will be removed for cause. Now, what happens if, during this question process, we come across a juror we don't particularly think will support our side, or will be disposed to our side, or maybe is just antagonistic to our perspective, but we can't get the person to the point where they say no, they won't be fair, or no, they can't follow the instructions? That leaves us with something called the peremptory challenge. Both sides can remove potential jurors peremptorily, and that basically means they can remove them for any reason they like. It doesn't have to be a good reason. It can be something as silly as they didn't have a book and they weren't reading it, or they gave me a funny look when I said this or that. Those types of things are sufficient grounds for removing the person. There are some limits on this, however. First off, you only get so many peremptory challenges. That's going to vary from place to place and jurisdiction to jurisdiction. Many jurisdictions limit it to 6 per side. Some places make it as high as 10 per side. Other sides are going to make it unequal. In federal court, for example, in the Southern District of Indiana, they had 10 peremptory challenges for the defense, but only 6 for the government. So this creates some strategy choices that the attorneys have to make. Who are we going to remove? How are we going to remove them? Which ones are the ones we need to pay attention to? The second limitation on peremptory challenges is that we cannot remove people solely because of their race or because of their gender. The United States Supreme Court has ruled in multiple cases that the use of peremptory challenges on the basis of race or gender violates not the defendant's right to a fair jury trial, but it violates the equal protection rights of the juror who has been removed. As a result, the remedy for that is the juror who is removed is now seated as part of the jury. There's one other complication to our jury selection process. Not every jurisdiction uses the same manner to question their jurors. There's 3 different ways of doing it. The first is we can ask all potential jurors at the same time all of our questions. So we can call this the veneer method. Here we might have 36, 42, we may have 56 potential jurors that are out there in the veneer, or the pool that we can choose from. We're going to ask all of those jurors all the questions all at once, and if any particular jurors have responses, the jurors will be questioned individually. Then when we strike people, we look at the whole group. That's one way of doing it. That is probably the most efficient in terms of asking questions. The second way that we can do it is more of a panel method. So we'll take the first 12 that are in our pool and we'll put them in the jury box and we'll ask them all the same questions and we'll address individual questions to jurors who respond. Then one side will make their challenges to that group, then the other side will get to make challenges to that group, and then anyone who's removed is going to be replaced by new potential jurors. We're going to go through the questioning again for those jurors, and then both sides get to remove until everyone is happy with the 12 jurors that are in the box. Our final way of doing it is more individual. This one, we ask every individual every particular question, and we do it one at a time. We never know who that next person is going to be, so that creates a really big dilemma when it comes to peremptory challenges. Is the person who's 3 away going to be worse than the person who you have in front of you? It really creates some difficult challenges when you're deciding which peremptory challenge to use. Once we get through that process, we have a jury, we get them seated, and we have to swear them in. Once we swear them in, then jeopardy has attached. In other words, we cannot stop the trial and start over again without the defendant's consent. It would violate double jeopardy. So then we go through the process of the case, we present the evidence, and now the jury has to decide. And so juror decision making is something of a black box. We have research that studies juror decision making, but they don't use actual jurors. No judge is going to allow researchers to use actual jurors because any type of recording, any type of filming, any type of observation of actual jury deliberations could impair the free flow of information during deliberations. As a result, no judge is going to risk a mistrial because of allowing some researcher to come in and study how jurors make decisions. So what we have is practice juries or model juries where we are going to study how they make decisions. And basically what has happened is we have created several theories based on this research in terms of how jurors reach their decisions. The first theory is what we call the algebraic theory. In this particular theory, jurors sit back, they listen to the evidence, they weigh the evidence, and from the evidence that they hear, they continue to adjust the probability of guilt. So they may hear a witness identify the defendant at the scene. The probability of guilt may be raised to 75-80%. As they listen to more evidence, they may hear that the defendant confessed to committing the crime. The probability of guilt now jumps up to 95%. But then all of a sudden the defense comes in with alibi witnesses. And these witnesses are very credible. And as you listen to those witnesses, the probability may continue to drop to 70 or 60. Then once all of the evidence has been heard, the jurors have a final conclusion. And they say, yes, we think that it is 90% certain the defendant is guilty, therefore we're going to find the defendant guilty. Now this particular theory has been refuted by subsequent studies. Jurors don't just simply weigh the evidence apart from everything else. Instead, what we have seen is something called the naive reporter theory be developed. And in this particular theory, the jurors sit back, they listen to the evidence, they take it all in, and as they do so, once they've heard it, they create a particular story in their mind about what happened. Now the problem is different jurors are going to come up with different stories about what happened, but they're going to create that story in their mind, and whatever that story dictates in terms of guilt or not guilty, then the juror is going to vote in that direction. The third model changes slightly from that. The naive reporter has them listening to evidence and then creating the story. The story model flips it around a little bit. Here, jurors going to hear what the charge is, and based on that charge, they're going to develop a story in their mind. So they may hear that it is a robbery case. And when they hear robbery, they may think, okay, somebody put a gun in somebody else's face and took a whole bunch of money. Well, what may actually happen during trial is the robbery's a little different. This may be a robbery of a Walmart where, as the person was leaving, they pushed a security guard out of the way. That's not our typical view of robbery, but it fits the legal definition. This would create a problem for the juror because the story they're anticipating and the story they hear conflict. And if that story they hear is too different from the one that they created, they're going to say, no, I have some doubt here about what happened, therefore we're going to find the person not guilty. If those stories match up, then the person is more likely to find the defendant guilty. This is why the opening statement is so important. In fact, research tells us that most jurors are going to decide the outcome of the case after they hear the opening statement. And so that is really the key piece of the trial after the jury has been selected. Jurors are also, when they're making these decisions, in a poor environment for decision making. Jurors are passive observers of the case. They sit there with nothing to look at other than the witness. Sometimes the witness examination may take 20 minutes, it may take 2 hours, it may take 2 days, depending on the case. They are expected to remember all of the little details of all of those questions as they're deciding the outcome of the case. Jurors don't have the benefit of recording testimony. Some jurors are allowed to take notes if the judge permits it. Some jurors are able to ask questions if the judge permits it. But if the judge doesn't allow it, the juror is just sitting there. Think about yourself. How often can you sit and listen to something without recording anything or taking any notes and pay attention to what's going on? How many of the details from this short video are you going to be able to recall even 10 minutes after that you have heard it? Jurors are at a distinct disadvantage when it comes to trying to understand the facts of a case based simply on the way they receive the information. In addition to that, they will have processing errors. Our brains are not perfect machines. We don't remember things perfectly. As a result, we often will take shortcuts, which we call heuristics, to reach decisions in a particular case. Let me give you an example of a couple heuristics. The first would be confirmation bias. In confirmation bias, jurors are listening to the evidence and they are only really accepting the evidence that fits with their particular viewpoint. So if they come in after opening statement presuming the defendant is guilty, they're going to automatically discard evidence that contradicts that particular story or that particular belief. Similarly, if they come in with a not guilty perspective, they're going to disregard evidence of guilt and make it more difficult to prove that the defendant is in fact guilty. A second one is what we call belief perseverance, where again, if we come in with a predisposed view saying the person is guilty, we're going to hold on to that belief even when confronted with contradictory evidence. It's going to take a massive amount of contradictory evidence for us to change our minds. And so we must, as jurors especially, overcome those heuristics. Finally, the last piece that goes into decision making is emotion. We like to think that jurors are machines, that they logically process the information, they piece it all together, and once they do that, they get the outcome. We call that algebraic model again, right? That is sort of the ideal juror, is they process this information, they weigh the guilt, and at the end, if it's sufficient, the person is guilty. However, that's not the way people work. There are emotions involved. In fact, emotions will play 3 different roles, or there's 3 different types of emotions that will have a role in the outcome of the case. The first is what we can call incidental emotions. These are emotions that you have simply because of how the day is going. So you may wake up, know that you have to go to the courthouse for jury duty, And you may be really upset about that. You may be very frustrated. You have to get up earlier than usual. Instead of going to work, you take the bus down to the courthouse. You've got to sit in this room with a whole bunch of people you've never seen before in really uncomfortable chairs, and you're just in a really bad mood. Well, you may show up in court, and that mood is going to affect how you perceive the evidence. You may be really vindictive and be very upset with the defendant. Why do we have to be here because of this? But then, of course, you hear the charge, and maybe you say, why do I have to take all this time for this stupid little offense? Right? So those emotions are going to play a role in how we perceive and how we think about the particular case. The second set of emotions are what we will call decision-relevant emotions. The particular case may be very emotionally charged. You may have a domestic relationship between the victim and the offender. You may have a young child who has been abused. You may have a young child who is killed, or a particularly tragic death in some way. All of these circumstances are going to generate emotions. And it may lead you to want to either sympathize with the defendant and allow the defendant to go home after a not guilty verdict, or it may want you to really blame the defendant for what happened, in which case you may be more likely to find the defendant guilty. Our third set of emotions are what we're going to call anticipated emotions. These are how we feel about what we might feel if we do a particular thing. So, for example, if you are deliberating and you think, wow, how am I going to feel if I let this person walk away from this case? Am I going to feel guilty if I find this person guilty on less than reasonable doubt evidence? All of those things are going to factor in. This is especially important in death penalty cases because jurors have to confront the idea that if they find the person guilty, they're going to sentence that person to death. And so they need to deal with those emotions and think, how am I going to feel after this case is over? And that also is going to factor in to juror decision making. We will move on to episode 9, the final episode in this series, where we look at appeals and we begin looking at, is this system really just an illusion of justice?